4. Abatement of nuisance estate of Gregoria Francisco vca Fax. A Quonset was constructed by the American Liberation Forces in 1944. It was purchased in 1946 by Gregoria Francisco. It stands on a lot owned by the PPA and faces the municipal wharf. By virtue of Proclamation No. 83 issued by President Elpidio Quirino, said land was declared for the exclusive use of port facilities. The PPA issued to Tan Jin San, spouse of Gregoria Francisco, a permit to occupy the lot where the building stands for a period of 1 year, to expire on December 31, 1989. The permittee was using the Quonset for the storage of copra. On May 1989, the mayor notified Tan Jin San to remove or relocate its Quonset building, citing Ordinance No. 147, noting its antiquated and dilapidated structure, and stressing the clean-up campaign on illegal squatters and unsanitary surroundings along Strong Boulevard. Since the notifications remained unheeded, the mayor ordered the demolition on May 24, 1989. Petitioner sought a writ of prohibition with injunction and damages before the RDC of Basilan. The RDC denied the writ and upheld the power of the mayor to order the demolition without judicial authority pursuant to Ordinance 147. On September 6, 1989, petitioner's Quonset building was completely demolished. In its place sprang shanties and nipa huts. The CA reversed the RDC and ruled that the mayor was not vested with power to order summarily without any judicial proceeding to demolish the Quonset building, which was not a nuisance per se. However, upon reconsideration, the CA reversed itself and ruled that the deficiency was remedied when petitioner filed a petition for prohibition and injunction and was heard on oral argument. Issue 1. The mayor could summarily, without judicial process, order the demolition of petitioner's Quonset building. Held no ratio, Ordinance No. 147, enacted on December 27, 1977, and relied upon by respondents, is entitled An Ordinance Establishing Comprehensive Zoning Regulations for the Municipality of Isabella. It is not disputed that the Quonset building, which is being used for the storage of copra, is located outside the zone for warehouses. It is referred to in ordinance as a non-conforming structure, which should be relocated. And in the event that an immediate relocation of the building cannot be accomplished, Sector 16 of the ordinance provides, a certificate of non-conformance for all non-conforming uses shall be applied for by the owner or agent of the property involved within 1-2 mo from the approval of this ordinance. Otherwise, the non-conforming use may be condemned or removed at the owner's expense. Even granting that petitioner failed to apply for a certificate of non-conformance, the provision should not be interpreted as authorizing the summary removal of a non-conforming building by the municipal government. For if it does, it must be struck down for being in contravention of the requirements of due process, as originally held by the CA. Moreover, the enforcement and administration of the provisions of the ordinance resides with the zoning administrator. It is said official who may call upon the city fiscal to institute the necessary legal proceedings to enforce the provisions of the ordinance. And any person aggrieved by the decision of the zoning administrator regarding the enforcement of the ordinance may appeal to the Board of Zoning Appeals. That a summary remedy cannot be resorted to is further evident from the penal provisions. Violation of a municipal ordinance neither empowers the municipal mayor to avail of extrajudicial remedies. On the contrary, the local government code imposes upon him the duty to cause to be instituted judicial proceedings in connection with the violation of ordinances. Respondents cannot seek cover under the General Welfare Clause authorizing the abatement of nuisances without judicial proceedings. That tenet applies to a nuisance per se or one which affects the immediate safety of persons and property and may be summarily abated under the undefined law of necessity. The storage of copra in the Quonset building is a legitimate business. By its nature, it cannot be said to be injurious to rights of property, of health, or of comfort of the community. If it be a nuisance per accidens, it may be so proven in a hearing conducted for that purpose. It is not per se a nuisance warranting its summary abatement without judicial intervention. While the Sangguniang Bayan may provide for the abatement of a nuisance, Local Government Code, Seconds 149, it cannot declare a particular thing as a nuisance per se and order its condemnation. The nuisance can only be so adjudged by judicial determination. Petitioner was in lawful possession of the lot and Quonset building by virtue of a permit from the PPA when demolition was effected. It was not squatting on public land. Its property was not of trifling value. It was entitled to an impartial hearing before a tribunal authorized to decide whether the Quonset building did constitute a nuisance in law. There was no compelling necessity for precipitate action. It follows then that the public officials of Isabella, Basilan, transcended their authority in abating summarily petitioner's Quonset building. They had deprived petitioner of its property without due process of law. The fact that petitioner filed a suit for prohibition and was subsequently heard thereon will not cure the defect, as opined by the CA. The demolition having been a fait accompli prior to hearing and the authority to demolish without a judicial order being a prejudicial issue. Technology Developers, Inc. v. CA. Facts: petitioner received a letter from private respondent acting Mayor Pablo N. Cruz, ordering the full cessation of the operation of the petitioner's plant located at Gyeong, Sta. Maria, Bulacan. The letter requested plant manager Armando Maines to bring with him to the office of the mayor on February 20, 1989 the following: A. Building permit, B. Mayor's permit, C. Region 3 Pollution of Environment and Natural Resources Anti-Pollution Permit, and of other document. At the requested conference, petitioner undertook to comply with respondent's request for the production of the required documents. Petitioner commenced to secure Region 3 Air Anti-Pollution Permit. Although among the permits previously secured prior to the operation of petitioner's plant was a temporary permit to operate air pollution installation, issued by the then National Pollution Control Commission and is now at a stage where the Environmental Management Bureau is trying to determine the correct kind of anti-pollution device to be installed as part of petitioner's request for the renewal of its permit. Petitioner's attention having been called to its lack of mayor's permit, it sent its representatives to the office of the mayor to secure the same but were not entertained. On April 6, 1989, without previous and reasonable notice upon petitioner, respondent ordered the municipality's station commander to padlock the premises of petitioner's plant, thus effectively causing the stoppage of its operation. Petitioner instituted an action for certiorari, prohibition, mandamus with preliminary injunction against private respondent. The judge found that petitioner is entitled to the issuance of a writ of preliminary injunction upon posting of a bond worth P50,000. During the MR, the provincial prosecutor presented his evidence prepared by Maivik Gina, due to the manufacturing process and nature of raw materials used. The fumes coming from the factory may contain particulate matters which are hazardous to the health of the people. As such, the company should cease operating until such a time that the proper air pollution device is installed and operational. The lower court then set aside the order which granted a writ of preliminary mandatory injunction and dissolved the writ issued. Issue 1 The writ of preliminary injunction should be granted. Held no ratio The matter of issuance of a writ of preliminary injunction is addressed to the sound judicial discretion of the trial court and its action shall not be disturbed on appeal unless it is demonstrated that it acted without jurisdiction or in excess of jurisdiction or otherwise, in grave abuse of its discretion. By the same token the court that issued such a preliminary relief may recall or dissolve the writ as the circumstances may warrant. The following circumstances militate against the maintenance of the writ of preliminary injunction sought by petitioner. 1. No mayor's permit had been secured. While it is true that the matter of determining whether there is a pollution of the environment that requires control if not prohibition of the operation of a business is addressed to the National Pollution Control Commission of the Ministry of Human Settlements, now the Environmental Management Bureau, it must be recognized that the mayor of a town has as much responsibility to protect its inhabitants from pollution, and by virtue of his police power, he may deny the application for a permit to operate a business or otherwise close the same unless appropriate measures are taken to control and/or avoid injury to the health of the residents of the community from the emissions in the operation of the business. 2. The acting mayor called the attention of petitioner to the pollution emitted by the fumes of its plant, whose offensive odor not only pollute the air in the locality but also affect the health of the residents in the area. So that petitioner was ordered to stop its operation until further orders, and it was required to bring the following: building permit, mayor's permit, and Region 3 DENR anti-pollution permit. 3. This action of the acting mayor was in response to the complaint of the residents of Barangay Giong, Sta Maria, Bulacan, directed to the provincial governor through channels. The NBI, finding that some of the signatures in the 4-page petition were written by one person, appears to be true in some instances. But on the whole, the many signatures appear to be written by different persons. The certification of the barrio captain of said barrio that he has not received any complaint on the matter must be because the complaint was sent directly to the governor through the acting mayor. 4. The closure order of the acting mayor was issued only after an investigation was made by Meivik Gina, who in her report observed that the fumes emitted by the plant goes directly to the surrounding houses and that no proper air pollution device has been installed. 5. Petitioner failed to produce a building permit from the municipality of Sta Maria, but instead presented a building permit issued by an official of Makati on March 6, 1987. 6. While petitioner was able to present a temporary permit to operate by the then National Pollution Control Commission on December 15, 1987, the permit was good only up to May 25, 1988. Petitioner had not exerted any effort to extend or validate its permit, much less to install any device to control the pollution and prevent any hazard to the health of the residents of the community. All these factors justify the dissolution of the writ of preliminary injunction by the trial court, and the appellate court correctly upheld the action of the lower court. Petitioner takes note of the plea of petitioner focusing on its huge investment in this dollar-earning industry. It must be stressed, however, that concomitant with the need to promote investment and contribute to the growth of the economy is the equally essential imperative of protecting the health, nay the very lives of the people, from the deleterious effect of the pollution of the environment.